My case number, WPA number 26237 of 2024.
25
26
oh 26
237 of 2024.
WPA 26237 of 2024.
Yes. Yes. Kindly take the writ petition first.
দাও ভাই দাও একটু দাও নেব সব নেব 26237
Yes. বসো দাদা, এখানে বসো। এই দাদাকে চেয়ার দাদা শোনাও ভাই।
Mr. Samim,
Yes.
you are SHAMIM.
SAMIM.
No, H is absent.
Absent.
Mr. Samim,
Yes.
so far your writ petition is concerned, the subject matter of challenge is the notice dated 9/8/2024.
Yes. Yes.
And further is your prayer for cancellation of the written examination held on 1/9/2024.
Yes. Yes. Yes.
Am I correct, sir?
Exactly. Now, madam, why I asked?
এই ফাইলটা দাও গো।
File.
26237 এইগুলো নামো আস্তে আস্তে। এইটা একটু কাছাকাছি রাখো, অর্ডার শিটটা এখানে রয়েছে তো। টু সিক্স টু থ্রি সেভেন ফাইলটা দিন। Mr. Samim, you have heard the argument of Mr. Mojumdar?
Yes, I will repeat. We will not repeat any single sentence.
Please add if you have got anything.
Yes. Yes. And I will, my lord, never cited the division bench because of that, my lord, already it is cited.
Yes.
Kindly take, my lord, page number 14 of my writ petition. Para 14. Specific aberrament. What my lord says that it's specifically avoided in my writ petition, original writ petition. Your petitioner,
Para 14 or page 14?
Page 14, para 14. In page 14, para 14, bottom.
এটা কোনটা দিলে কোন তাহলে 26237?
Yes, my lord.
Page 14, there is paragraph M and N.
No, my lord. I believe para 14. Page 14, para 14. I believe the other writ petition is given to my lords.
I'm sorry, it is, I'm seeing the AVAB now.
It's original writ petition, my lord.
I got it. Sorry.
It's okay, sir.
Yes, sir.
May I start, my lord?
Yes.
Your petitioner state that the action of the commission is also contrary to the recruitment rules. There is no provision to conduct a separate written examination. That's my point. There is no mechanism mentioned in the recruitment rules to meet up the problems of separate examination. The question paper were not same in case of separate examination. An easier question may given in new examination to make a pathway for their favorite examination. In other examination where two or more separate question paper were set, in many cases, normalization mechanism were followed. But in the instant case, there is no such mechanism to put all participants in same footing. In what happened, my lord, in central government, suppose 2 days or 3 days, the examination is conducted. In the case of railway, they adopt a mechanism that's called normalization mechanism. But here, my lord, I will place the recruitment rules later on. Because in that examination, if you want to put separate sets of question paper, then you ought to adopt a mechanism, that a modern mechanism that's called normalization. Normalization, scaling, all are the mechanism to meet up this type of problem. But here the case is that, my lord, they complete dehorse the recruitment rules. I will place the rules later on. Before that, my lord, I place my case, my lord, in pleadings, my lord. No such mechanism to put all participants in same footing. Recruitment rules did not mention about any such mechanism, but the commission has taken a separate written test for the 73,978 candidates. The action of the respondent commission cannot sustain in the eye of law. Therefore, said notice dated such and such and the impugn action of the respondent need to be set aside as early as possible by the Honorable Court. Para 15. Your petitioner state that the notice by the commission is bad in law, bad in the eye of law. It is contradicting the order of the Honorable Division Bench. That means 13 June 2024 Division Bench order. The petitioner state that it has been decades since the examination was held. The writ petitions filed before the Honorable Single Bench was with the prayer for publication of result, which has not been complied with. The petitioners, along with several same-footing candidates, are suffering due to the delay, and holding another written test would create further complication and delay, and the petitioner will be deprived of the opportunity. The commission cannot conduct a fresh examination of same candidate. The examination process need to be declared as bad in law. Now, my lord, what was the commission stand in earlier before the division bench, my lord, through can 20, which is annexed with the comprehensive affidavit. My lord, kindly take the comprehensive affidavit.
comprehensive affidavit লাগবে কোথায় গেল comprehensive affidavit কোথায়
Comprehensive in comprehensive affidavit.
নামালে ওটার মধ্যে আছে
No, no, no.
24588 এর মধ্যে আছে
একটাই স্যার পেজ নাম্বার 152
24588 এ পাঠাবো কেন খুলতে বলেছি দেখেছো তো আজকেই খুলবে সব yes
my lord, kindly take page number 152 on 13 June 2024.
give me a second yes
On 13 June, my lord, this application was moved before the division bench. In connection with MAT 907, can 20 was moved before the division bench. What was the pleadings in this can? That is important. 152, page number 152. We start from page number 152. I just skip the para 1 and 2. Para 3 is very relevant.
yes
I read. The appellant, that means the appellant commission, state that on 19 September 2023, during the pendency of such application, the had already taken a policy decision to conduct a fresh written examination of total of 1,164 candidates. The commission take this policy decision. My first question is that from which provision of law they got this power, empowered? How the commission is empowered to take a policy decision after finishing everything, they will conduct a further written examination. Now, a very interesting fact came out thereafter. Of conduct a fresh written examination of a total of such and such candidate, that is 74,618 eligible candidates, which were left out along with 26,444 candidates who had already appeared in the written examination of Group D held on 29th May 2011. The appellant state, the very next paragraph, the appellant state that upon passing of the order dated such and such, the following step has been taken to comply with the order passed by the Honorable Court.
Mr. Samim,
Yes, my lord.
so far as paragraph number 3 is concerned,
Yes.
What is the stand of the commission? The commission intends to take examination of all the candidates.
No, kindly take this. May I read again?
Commission had taken a
It will clear by the last two lines. Page 156. It is cleared by the last two lines. They want to conduct further examination, although this is not very clear, but the intent is that the spirit of this paragraph is that they want to conduct fresh examination in respect of 74,000.
Just a minute, sir. Had taken a policy decision to conduct fresh of a total of no, Mr. Samim. Paragraph 3 says such and such had taken a policy decision to conduct fresh examination of a total of 1 lakh and what candidates.
Yes.
So their intention is to take fresh examination of the candidates of 1 lakh and what? That is 74,000 and odd eligible candidates, which we have left out along with.
That
so
is.
They intend to take the fresh examination.
Thereafter, the sentence is not yet completed. That is, i.e., 74,618 eligible candidates, which were left out, along with 26,445 candidates who had already appeared. That means who already appeared, which will be more clear because of they give a tabular chart.
Mr. Samim, paragraph 3 clearly indicates that the commission had taken a policy decision to conduct a fresh written examination of total 1 lakhs and odd candidates, which includes 74,618 were left and to plus 26,440
already appeared.
So total will come.
That is the number. Because of that, kindly take page number 4 of this comprehensive.
Just a minute.
Before that, kindly, if my lords wants a list of date, that will be give a clear picture to before this court, my lord. Page number 4 of this comprehensive affidavit.
Just a minute, sir. 74,618, 26,415. Sum total comes to 1,063, 64.
Kindly,
they intend to take a
yes. No. Kindly take my lord page number 4 of this comprehensive affidavit. Page number 4.
Just a minute.
It give a list of date that will give the clear picture of this about this matter. How this matter is cropped up. Para 5.
Page number
4 of this comprehensive, because this is it will help the court to ascertainment the fact. List of dates. The first entry, that is 27th March 2010, that is the publication of the advertisement date. Second entry, the commission conduct preliminary examination on 28th November 2010. The third entry, about 26,000, which my lord asked me about this 26,000. On 29th May 2011, already 26,445 candidates, they appeared in the written examination. There are second stage. So they appeared. What they did, they says, I will read the whole application. Because of that, what is the necessity of the reading, that will give the clear picture. I just put this list of date. Why? Because of that, it will give the clear picture. On 12 March 2014, the High Court order. Thereafter 9th December 2015. Thereafter 14/3. I just skip over. They even quoted in their tabular chart, and kindly take entry number 13. They even took cognizance of the division bench order. They already complied the division bench order by giving the cost portion. They can't take the contrary stand now. They already complied the order because they already gave the 2 lakhs cost. Now, after that, because this order came out after this application, moving this application, I will tally this application along with this comprehensive affidavit. Why? Because they took, which is already the decision is taken by the division bench. Now they wants to re-agitate the same issue. Even the paragraph is total the same. I will compare this to affidavit, this application along with this comprehensive affidavit. I will tally it. That's why I place this application. Now, my lord, kindly take para 5.
Para 5 of what?
Of this scan application, page number 158. Page number 158. 8. They are comprehensive. The appellant further state that they have issued letter dated such and such to the district magistrate seeking for the availability of examination center to enable the appellant to conduct examination shortly. That means fresh examination of left out candidate. Such information regarding the availability of examination center is of vital importance for the issuance of admit card. Copy of the letter such and such. I just skip this portion, para 5, para 6. Now kindly take paragraph 8 and 9. 7, 8 and 9.
Page number
160. Got it, my lord?
Yes, sir.
Para 7. It is stated that as a result of aforementioned pre-scheduled business of appellant, that is conducting recruitment process of assistant teacher, the appellant have been under immense pressure and were unable to complete the entire recruitment process for the post of Group D in terms of order dated 12 September 2023. That paragraph 8, that the order dated 12 September 2023 is due expire on 11 March 2024. However, the appellant, despite the best effort, were unable to complete the entire process of recruitment of Group D candidate. Were unable to complete the entire process of recruitment of Group D candidate within such time frame as directed by this honorable court. Paragraph 9, very interesting. The appellant further state that they have received letter from the district election officer stroke district magistrate for the requisition of numerous staff of the West Bengal Madrasa Service Commission for the upcoming general election to the Lok Sabha 2024. Copy of the letter received from the district magistrate election officer stroke district magistrate is annexed here too and marked with letters such and such. Now, my lord, kindly turn page number 19. Now their stand. What is their stand? Same stand. Para 19. M. Paragraph M. Paragraph 19. That after 12 September 2023, the commission again started process of re-evaluation of the OMR sheet. My second question, my first question was that from where they got this power to conduct a further written examination, because there is no such normalization procedure, because separate set of question paper. That is my first points of agitation. Second point of agitation, this re-evaluation. From where they got this power of re-evaluation of OMR sheet? Because if they want to re-evaluate the OMR sheet, there must be some statutory backup, because division bench is very clear. And
Give me a second. Yes, Mr. Sami.
yes, my lord. So there is no such provision of re-evaluation of OMR sheet. My second point, re-evaluation of OMR sheet of all the session and preliminary examination for the
Second or third point. Your
the
first
third
point
yes,
was violation of recruitment rules.
yes.
Your second point
There-
was no mechanism has been followed for normalization of the recruitment process.
There is no rule regarding second time holding of the written examination. So
And
there is
third is no power to re-evaluate the
the
OMR.
OMR. Yes,
As
I'm
per
grateful.
the
Yes,
recruitment rules.
yes, I'm
Those are
grateful.
those are the basically 3 points.
3 points. I will come up another points also.
Very good.
Normal re-evaluation of OMR sheet of all the sessions of the preliminary examination for the post of Group D held on such and such date with proper answer key of those respective session. And thereafter, it was detected that 73,978 candidates who had appeared in the preliminary screening examination for the post of Group D on such and such date were eligible for written examination held on such 29th May 2011, but had not allowed to sit in the said examination held on 29th May 2011 due to the technical error of the commission as stated herein above. The commission could not complete the whole process due to Lok Sabha election 2024. After completion of the Lok Sabha election 2020, the same point, because of the earlier occasion in Can 20, they took the same point. Here also, they took the same point. And the fate of the Can 20 is already decided by the division bench. How can they re-agitate the same point which is already decided? That's why I compare this paragraph with the earlier application. May I place the division? Sorry.
Are you in a hurry, Mr. Samim?
No, no, my.
Let your judge note.
Because I, এরকম বদমাশ না?
So, Mr. Samim, would it be your contention that the point or the defense has taken in this comprehensive affidavit is, since it is identical with CAN 20 of 2024 in connection with MAT 907 of 2018,
Yes,
and since it has been, those issues have been decided by the division bench,
it is.
so the defense taken by the commission operates as a res judicata.
Yes,
That is your
yes, that's my point.
Let me note, sir.
Yes, my lord. And now, my lord, the third point is, the fourth point is that, my lord, how the
Yes, sir. Next.
my lord, now, my lord, I wants to refer the rule position. What is the rule position? This is the 2010 rule, my lord. Just 10 rule. This rule called, because this selection process first SLST 2010 non-teaching staff is the rule regarding this matter.
মার্ক করো, ওই মার্ক করে রাখো WPA 26237 বলে, ওই যেটা দিচ্ছেন উকিল বাবু, নাহলে খেয়াল মনে রাখতে পারবো না, ওটা নোট করা হবে। ইন WPA 26237 of 2024.
Yes, ma'am. 2006. রিপোর্টেড হয়ে গেছে রে, রিপোর্টেড পোর্শনটা নিয়ে নেন, আনরিপোর্টেড অনলি রিএভ্যালুয়েট করা যায় না। লিখেছে
West Bengal Madrasa Service Commission recruitment, selection and recommendation of persons for appointment and
And-
transfer to the post of teacher and non-teaching staff,
Rules 2010.
2010.
Yes.
Very good.
Kindly take note of the rule, that is rule 12 onwards, my lord. Specifically, I want to canvass rule 14, 15, 16, 17, specifically rule 17.
Chapter 5.
Yes, my lord. Chapter 5 onwards, my lord.
Which rule you want to refer, sir?
Rule 11 onwards, my lord, because that is rule applicable to this.
That is chapter 5.
Yes, my lord.
Chapter 5 and chapter 6. I
Yes,
think.
madam. Chapter 5, chapter 6, and chapter 7. Specifically, chapter 7 is very important because there is about evolution. There is no such provision of
Chapter
re-evolution.
5, chapter 6 and chapter 7. Yes.
My lord, Rule 11 says about the form of application and fees thereof. I just skip it for the time being. Rule 12 is about submission of application. And Rule 13 is processing, screening of application. For the time being, I just skip it. Now, my lord, Rule 14, issuance of admit card. For the time being, I skip it. Rule 15 is very important.
Yes.
Rule 15 says about arrangement of written test, not tests. In singular form. The commission shall arrange for written test, not tests, under its direct supervision and control. The commission shall determine the scheme and syllabus of the written test, not tests. Prepare question paper and distribute the same to the examination venue through the custodian appointed by the commission. The commission shall appoint paper setter, moderator, observer, approve the list of examiners and experts, fix the rates of remuneration for paper setters, such and such. The commission shall determine the number of papers for the written test, content each paper, duration of examination, and other matter relating to the state region, such and such. Rule 16. Holding and conduct of written test. Again, written test. The commission shall hold written test of all the eligible candidates. They are also the written test, not tests. The commission shall decide the procedure and the manner of conducting the state, region, area of level selection test, and the prepare details instruction in this regard in accordance with the provision of the Act and the rules made thereunder. The commission shall select examination. For the time being, I'll just skip it over. Rule 17. That is evaluation. Very interesting. Evaluation of answer scripts sheets. The commission shall get the answer scripts sheets of the written examination evaluated by the examiners, computer-based technique, and prepare a evaluation sheet, medium, post, subject category, and gender-wise on the basis of such evaluation. Now, preparation of list of candidates for opportunities. After the evaluation of answer sheet of the written examination, the commission shall prepare medium, post, subject-wise categories. There is the provision. So there is no such provision about second time written examination. That's my point.
That is called multiple test.
Yes, it never be a multiple test. If you want to adopt the multiple test, then there must be some provision in the rule itself. It is happened in the case of railway examination. It's happened in the case of staff selection examination. Because in that type of examination, there is in the advertisement as well as the rule, there must be the specific provision. In that provision also, they says we adopt the process of normalization or scaling. So there is no such mechanism of second time test. And one go, you ought to take the written examination. It might be the multiple center. There is another point is that there is no such provision of re-evaluation. Because
give me a second.
পয়সা লাগবে।
The recruitment rules does not prescribe any re-evaluation.
My 2 point is there. In recruitment rules, there is no such provision of second time written examination. There is no such provision of re-evaluation of OMRC. Because re-evaluation, there is a hell and heaven difference between evaluation and re-evaluation. Because this is a statutory body. And statutory body, this statutory body, West Bengal Madrasa Service Commission, is empowered by the statute.
The rules have to be finalized before holding examination.
Yes, this rule framed by the state authority, and they, by adopting this rule, they process this selection process. So being a statutory authority, they can divorce the rules. Divorce the rules amounts to the,
Understand. What is your next contention, Mr. Samin?
my next contention is that, my lord, I just summing up is, my lord, that is all, my lord. I just summing up this, if my lords want, because of this is a settled proposition of law that re-evaluation is not permissible, because in our division bench hold it very recently in upper primary examination, the re-evaluation is not permissible if that is not backed by the statute. That is, I want to refer it. I will refer it later on if they wants to contradict it. Say,
Please refer so that I can.
আমি দিয়ে দিচ্ছি judgment. Okay, আমি just summing up করে দিয়ে দেবো okay okay
I think it's very clear that by the using the word evaluation, my learned friend should indicate that
If it is not clear, it will go in your
yes your term.
something you need to make it
Maybe. If the argument of Mr. Samimi is not convincing, it will
Yes,
be-
you will agitate it. You will agitate it. You will agitate it.
So, Mr. Samim, please sum up.
Yes, my summing up this, my contention is that in three proposition of law. First is that, my lord, there must be a level playing field, because in our country there is no such right of employment. Equal opportunity in public employment, that's the fundamental right. If suppose two examination was conducted, in one sets of examination, easier test might be happen, and suppose the Article 12 authority might choose their favorite candidate in that sets of examination. So that's why the modern technology adopt, that is normalization. So it is because a huge number of participating candidate in that selection process might be happen. So that's why normalization process was adopted in that type of examination. But here there is no such provision, so that is not permissible. Second thing is that they did it. That means they divorce the rules. If they did it by divorcing the rules, it amounts to not giving the equal opportunity to all the candidates. It is liable to be set aside their action. Third point is that, my lord, that is, if they want to re-evaluate the OMRship, that must be backed by the statute. There is no such express provision of law to re-evaluate the OMRship. And my fourth point is that regarding the second time written examination, already division bench hold it, that is not permissible. So that is res judicata. That's 4 points. That's right. That's extremely grateful, my lord.
Any other want to join in favor of the petitioners?